Hello and welcome to Point One. 6 minutes of ethics a day could keep the legal malpractice claims away. I want to talk about the second element of a legal malpractice claim and the interaction with the ethics rules. The second element is really what most people refer to when they say that would be legal malpractice. It's the negligence element, the breach of the standard of care. And, it's important to always remember that the breach is not enough. If any element's missing, and the elements again are privity, the attorney-client relationship, number one, number two, the negligence element, number three, proximate causation, and number four, actual and ascertainable damages. If any of those elements are missing, then dismissal is appropriate. So the breach of the standard of care in New York and elsewhere, attorneys must exercise the care, skill, and diligence commonly exercised by other attorneys in similar conditions and circumstances. So, the idea there is we have this average attorney in similar conditions and circumstances. So a real estate attorney up in Plattsburgh, New York is not going to be held to the same standard, in theory, as a real estate attorney in Manhattan. Just different conditions and circumstances. So you're being judged by the standard of your peers. I want to talk quickly on the professional judgment rule. And basically, there's variations in most states, but the basic idea is that the court is not going to look back on what the attorney chose to do in the course of a litigation or transaction with perfect hindsight. And if it was a reasonable professional judgment call, then the court won't challenge that, and technically a legal malpractice claim can't be based on it because there is no breach of the standard of care there. Again, it has to be a reasonable course of action. And the case law, it gets pretty fact specific, but that's out there. And if it was a reasonable decision on the attorney's part, it won't be challenged. New York doesn't use affidavits of merit, but in other jurisdictions, an affidavit of merit is needed. In New York, experts are useful in the legal malpractice context, but also not always needed as they are in some jurisdictions. Ethical considerations and the breach of the standard of care. Again, you have to know, as always, your jurisdiction's rules. The ABA, New York rules, most states' incorporated rules recognize the distinction between an ethics issue and a legal malpractice or other claim against a lawyer. And the preamble and scope specifically outlines that the rules are not designed to create a cause of action against an attorney. However, the standard of care is typically admissible, and the rules can be used as evidence of the standard of care to then attempt to show a breach of that standard of care in a legal malpractice claim. So while the rules aren't there to establish a cause of action or even to establish the element of duty, they can be used to do that. So it's very, there's a direct correlation there. Again, not so much a New York issue, but if jurisdictions allow specialization in the law, a certificate as a tax attorney or something like that, you have to pay special attention to that expertise and the rules surrounding that. But also, that ties back to the standard of care of a similar situated attorney in your community. If you hold yourself out as an expert in another jurisdiction, as a real estate expert, if you're allowed to do that in the other jurisdiction, you could potentially be held to a higher duty in New York if you hold yourself out as an expert in a jurisdiction that allows you to do that. And just to be aware of issues regarding practice in other jurisdictions, especially now with COVID and the remote practice of law. Obviously, you have to know the rules of whatever jurisdiction you're practicing in. You have to know the rules of whatever jurisdiction you're sitting in. You potentially have to know the rules of jurisdictions where your clients are, and the interaction of all those rules. So, the duty here has been magnified, amplified a bit by the COVID situation and also just by technology in general. But that practice in other jurisdictions can lead to increased risk. And really, in my experience, not only does it lead to increased risk in claims, but it then, becomes a much harder claim to get rid of early on a motion to dismiss. Because when there's conflicting duties out there, I find the court to be, likely to punt and say that they've pled a cause of action here, and we're going to need discovery to see if there really was a breach. And so just be aware of that and be careful of that. Not just for potential legal malpractice claims and a breach of the standard of care, but for practice in general. It's a developing and ongoing risk to attorneys. That's been our point one for the day. Thank you for joining me.